So in this video I want to discuss the relationship between a claim made in a civil court in Ontario for human rights violations and an employment law case for wrongful dismissal. Ontario is the only jurisdiction in Canada that allows a human rights claim to be brought by civil action. Every other jurisdiction, one must proceed through the Human Rights Commission. So in Ontario, you can sue civilly for a human rights complaint and or through what is called the administrative process through the Human Rights Board. But in Ontario, again, you can sue civilly as long as there is a companion action. And then the issue comes up, well, if there is a damage award made for human rights violations, how does that integrate with aggravated damages or punitive damages? And there is a leading case in Ontario in the Court of Appeal in 2017 dealing with a woman who was deaf. The company failed to accommodate her disability, in fact, tried to force her to resign, which was not successful, and then developed a fictitious reason to terminate her based on alleged performance deficiencies. To make matters worse, after it terminated her, it played games with her employment insurance record of employment, which delayed her eligibility for employment insurance benefits, and also failed to pay sums of money that was due to her on termination of employment. So basically a very ugly case. When the case went to trial, the trial judge awarded $20,000 for a human rights violation, but determined that he was not able to award aggravated damages for unfair conduct at the time of termination because of the award of the human rights damages. Well, this all went to the Court of Appeal, and the Court of Appeal, first of all, increased the human rights award from $20,000 to $40,000, which is exceptional for them to interfere with that first assessment, and also determined that the human rights award could not impact the award of aggravated damages due to unfair conduct. So they added on another $75,000 in aggravated damages for the unfair conduct of the employer, and to make matters even worse for the employer, added on an additional damage claim of punitive damages of $55,000. So the end result of this case and others that are all detailed in the summary I've attached below is that an award made of human rights damages is distinct. It does not impact or moderate the award of aggravated damages. This is all bad news for every employer, but it also hopefully will lead every employer to act fairly and honorably to its employees. In this case, it was particularly an ugly case and resulted in a huge victory for the plaintiff. There are other cases that I've summarized in the chart that I've attached in the description below that details not quite similar but comparable situations in which awards have been made of human rights damages and aggravated damages without overlap.